This isn't just another courtroom hearing. This is a case where time tried to bury the truth and failed. A man stands accused decades later as witnesses finally speak, inmate phone calls surface, and long-hidden evidence comes back to haunt him. What started as a missing person case turns into a murder hearing with shocking testimony, forensic discoveries, and a secret that stayed hidden for 25 years. Stay with us because every word today brings the courtroom closer to a truth that was never meant to surface.
Good afternoon. We are here. It's cause number F0389302, and this is -0-B. The state, Mr. Coleman is here, and is it Udishin?
Udishin, yes.
Udishin is here on behalf of the appellant, Mr. Garner. Just so that we're all on the same page. And ma'am, I'm sorry, what is your name?
Caitlin Gilbert, Assistant Special Texas for Mr. Garner.
Thank you. And Gilbert, you said?
Yes.
Thank you, Ms. Gilbert. And so what we're set for today, I want to take care of a couple of things. One, the appellant or applicant, I guess what's the proper, what are you?
We're the applicant.
Okay, so the applicant has requested, filed a motion for some production of records. And Mr. Coleman filed a response, which I reviewed, to which Mr. Udishin filed a response to that. And I've reviewed that as well. And I will let you both, I've read everything. I don't think we need to take a whole lot of time on this. I'll tell you where I am in general on this whole matter. And that is, I really think on both sides, whatever the experts need to look at before we get here for trial, then I think they need to look at that. And so I don't want to pick and choose and then later have the Court of Criminal Appeals say that I should have done something and we're back here doing this again. So I'm inclined to grant that motion. I understand your position, Mr. Coleman. If there's anything you want to put on the record outside of your response, I will allow you to do that. I think on behalf of both of you, whatever y'all need, I'm going to get it ordered so that when we get to the point where we're here for the battle of the experts or whatever it's going to be called, then everybody has had everything to look at and isn't going to stand up and say, well, I don't know because I didn't see something. So I'm willing to do that for both sides, whatever you need. Anything, Mr. Coleman, with regard to that specifically?
Your Honor, the only thing I would point out is that in the Court of Criminal Appeals most recent case dealing with shaken baby syndrome or abusive head trauma, the Hovarth case from 2025, from this year in June, the court made it clear in its denial of the application for a writ in that case that in order to obtain writ relief under these circumstances, the applicant must show new scientific evidence is available which contradicts, and I'm reading directly from that case, that contradicts the scientific evidence presented at trial. They made it clear that the focus is on the evidence that's presented at trial. In fact, I've printed out a copy of that case. I've highlighted that relevant portion if the court wants to look at it. But that's kind of the crux of my argument from a 30,000-foot level view of my reply.
Sure. Is
that the focus should be on what was presented at trial. I think that that's an inference from the plain reading of the remand in this case, that the Court of Criminal Appeals wanted the focus to be on the evidence presented at trial. And also, if you look at this language from that most recent ruling from the Court of Criminal Appeals in Hovarth, that was the focus. And I likewise would ask the court to limit the scope to what was presented at trial, Judge, just so that we don't get far afield of what our task should be.
No, and I agree that we're going to stay on task. We've got to. I mean, there was a very specific remand, very specific questions to be answered. I'm looking at it now, and the part that I think at least allows you guys to look into this stuff. Now, what I allow in and what I find necessarily relevant at a future hearing could be very different. But I don't think we will know that, or the experts won't know until they look at everything. The part that gives me just a little more, I think, leeway or to get this information out there and to grant this, The way it reads is the trial court shall make findings of fact and conclusions of law as to whether applicants' allegations and previously unavailable medical and scientific evidence, and then we've got number 1, number 2, contradict what happened then. And so, again, we're not going to go down the whole any and all allegation. It's going to be with regard to the scientific evidence, specifically, obviously, shaken baby syndrome and what evidence there was. Just because something wasn't admitted in trial, I don't believe that that is off limits, because that was a choice made by a prosecutor back then. And then, so we'll, which obviously was none of us were involved at that point in this case. So I appreciate the, and understand and don't completely disagree, but I am going to grant the motion for production, and that was filed. So then the only other thing that I really want for us to nail down is some type of scheduling order for us to live by kind of between now and our date, which we have been granted the extension to
June 15th.
June 15th. And so June 15th date is obviously the date when the findings of fact and conclusions are due. Our trial setting is April?
March 22nd or 23rd.
I should know that, but I walked in without knowing. Can you look real quick and make sure we're working backwards from the right date?
And Judge, I have one suggestion when you're ready to
Sure.
make about all this.
Sure, go ahead while we're figuring that out.
First of all, we made a notebook of all the cases we keep talking about for the court. If this
That would be
would
great.
be helpful to you.
That would be great. And obviously, any case that's in here, Mr. Coleman, if you want to look through it, make sure those are cases so that if I'm referring to a case, you'll be able to do the same. But I do appreciate that.
And Judge, the Rourke case, which is the remand space one,
Right.
that was my case. The Horvath case that was just referred to is also my case. So I've been steeped up to my ears in shaken baby cases for the last 20 years. One thing, when I was litigating the Horvath case in particular, that was out of Ellis County, we asked the Court of Criminal Appeals to delay having to do anything on the Horvath case until the court decided the Rourke case. And I think maybe what we should do is ask the court to delay the resolution of this case until we get a decision on the Roberson case, which I know the court's familiar with the Roberson case, the death penalty shaken baby case from Anderson County.
Right.
But that's currently under a remand order back to the trial court that's real similar to the remand order here. And so a lot of the issues that we're going to have to address here on the Garner case are ultimately going to be addressed on the Roberson case. And if we,
I guess so, just to make sure that I guess the problem that I see with that is that it's fact specific. The questions are fact specific that the Court of Criminal Appeals sent down, that I'm to make a determination whether or not in this case, certain facts, either if you take out, for lack of a more scientific way to put it, take out shaken baby syndrome, and was there enough other evidence, medical or otherwise, to sustain that jury verdict? And so I'm not sure I would understand, or I understand why another case at that point. I feel like we've got the law, they've remanded it, and it's a fact-specific remand for me to make the findings in this particular case.
Well, Your Honor, I agree. The real reason why I'm bringing this up is part of the state's argument, or at least what I gleaned from their argument, is they want to challenge the holding of the Rourke case. They want to make an argument that there really isn't any new science on shaken baby syndrome. If the court is not inclined to get back into the whole is there new science argument and just decide whether or not the Rourke case, the new science, applies to the facts of this case, which is the position that we think is appropriate, then I agree there's not necessarily a reason to wait for the Roberson opinion. But if the state intends to bring in evidence and to relitigate or attempt to relitigate the new science question, then maybe we should wait for Roberson.
Mr. Coleman, I don't think so. What they've asked or told me to do is very, I mean, it's very narrow in my opinion. And so relitigating it, we're not relitigating everything. Between now and our setting, I'm going to have to read the entire transcript because I can't make the decision that they're asking me to make and make findings if I don't know what other evidence there was. Specifically, I mean, they're saying if other evidence were presented, would it have by preponderance of the evidence meant that the applicant would not have been convicted. And so it's going to be necessary for me, number one, to know everything that was presented. The new science is what this is all about. I guess I don't want to misunderstand. I think y'all are kind of both saying the same thing, just different ways. Like it's going to be, you're going to have experts that come tell me because of the new science, the by preponderance, you're going to have experts that might come say that, and I have to listen and determine credibility and what else was there in the trial and do it that way. So I guess I'm not inclined at this point to ask for an additional extension. I will talk with, Mr. Florence is here. You guys both, Tommy knows him, of course, but Gary, I'm sorry, first names. Mr. Coleman, Mr. Udishin, Mr. Florence is sitting on the first row, who is our briefing attorney. And so I'll discuss all of this with him. And if there's some reason we feel like that would change or my opinion would change to ask for more time, then I'll get back with you guys and do that. But for now, let's at least work on scheduling as if we were going.
I'm sorry.
Your Honor, and if I may briefly, I'm sorry to interrupt, Mr. Udishin. Your Honor, complete agreement with the court wholeheartedly. Just to put a fine point on that, Rourke ruling itself makes that determination, in my opinion, that it was a fact-specific determination. I'll read just briefly some excerpts from that case. Rourke states that there remains some controversy with regard to the quote-unquote new science, and that the consideration of the new science considered as a whole, specifically in this case, was determinative because this was, as they put it, a circumstantial case. In other words, a fact-specific determination about that case, which is not unlike the fact-specific determination the Court of Criminal Appeals has tasked this court with making in this case.
That's where I am.
No, I agree, Your Honor. Just for clarification, I believe the state has said in some pleadings on the Garner case that, at least it appeared to me, that they were intending on making an argument that there isn't any new science, contrary to what the Rourke opinion said. And I believe what they're saying is they're quoting Judge Urey's dissent from some of these cases. And if they're intending on making that argument, then that's, I think, is inappropriate under the remand and the law at this point. And just so we know what to prepare for, I want to clarify that.
Judge, it's my pleadings. I think I'm the best person to speak on the intent of my pleading. Your Honor, what the argument or the gist of the argument will be is that there's no consensus, Judge. There very well may be some opinions out there as to whether or not there is new science or in this area, but it's the state's position. We believe their experts that we bring will bear this out, that there's a lack of consensus in that medical field, in that community.
And it doesn't matter, and Your Honor, it doesn't matter if there's a lack of consensus because you have the Rourke case, which is the law in Texas. So it doesn't matter if somebody disagrees with the Rourke case. It's the Rourke case that we're talking about.
Right. And so, okay, so I think, at least for now, you guys know where I stand. And the position that I am in is I believe it's fact specific with this case. I think you guys, I'm going to get you the production you need, whatever y'all need with regard to experts and production of any evidence that will help those experts come up with whatever opinion they're going to have, and then ultimately it'll be a decision that I make in my findings and conclusion after hearing all that. So let's, and again, if there's some change in where I'm thinking on, or what I'm thinking with regard to asking for an extension based on that other case, then I'll let you guys know that real quickly. So with regard to, what are y'all's thoughts? I mean, obviously on the normal cases we have here, I'm not doing scheduling orders. I want everybody to have plenty of time. Do either of you have some ideas on, do we need 2 months out, a month out? Do we need to meet every month until then? Do we need, what are y'all's thoughts on making sure that we're all on the right path to where we need to be going?
I've attached a proposed scheduling order to my motion requesting a scheduling order.
You did. Let me see.
And I would suggest maybe we kind of use that as a template.
Have you seen that,
I
Mr.
have,
Yudishin?
Your Honor.
Let me get it pulled up and we can just,
While you're pulling that up, Judge, my thought process at least is to work backwards from our deadline of June 15th.
well, I think we would need to work backwards from the trial deadline. Between trial and June is all me, AKA Mr. Florence, and me getting my findings together. So once the trial's done, it's a matter of everybody potentially submitting their own findings that I review, and then we come up with our own. So I think we need to work from trial backwards, right?
I was thinking, so are we keeping the March hearing date?
Yeah.
Okay.
That's
Because
where
I was
we are. That
thinking-
they've given us until June 15th. So, I mean,
I was thinking that because we got moved out to June 15th, then maybe the hearing date would get moved out. My preference would be, Judge, to have a hearing date at least a month before the June 15th date. I guess that puts us like in.
no, we want for at least that, if not more.
Yeah.
No, at this point, I just as soon keep March. We all kind of agreed, I think, on that date, right?
That's a date that works for our witnesses.
And I think we looked, Mr. Coleman, at your schedule, and you didn't have an issue. Honestly, I'd rather just go ahead. I have that already on my trial calendar to not have jury and things like that week.
What was the date again?
Well,
I've got it on my calendar. Okay, so we're gonna keep the March hearing date, all right?
correct. And so let me, yeah, let's do that. And then,
And Your Honor, if I could make one comment.
and you guys,
about-
y'all can,
Oh.
let's just work through that.
Okay.
I know it's habit to stand, and I appreciate it, but just for working on this, go ahead.
Your Honor, we're not opposed to a scheduling order. The real question is whether you're going to authorize depositions, interrogatories, and requests for admissions.
I'm going to authorize whatever y'all want to do.
Okay.
Honestly, on both sides. If y'all want to take depositions, I think any of that, hopefully, if I allow all that, it makes my life easier that week. So on both of you, whatever y'all need with regard to depositions, interrogatories, requests, admissions, whatever you want to do, I'm going to allow it. Obviously, if there's some super far-reaching request that someone has and there's an issue, then we can get something set for a hearing very quickly. We can also, if necessary, take care of some things since it's just us at this point, and we're not having to worry about having Mr. Garner here for this yet. We can do things by Zoom if we need to have some just you and I and Mr. Coleman and the court reporter potentially if we need to work on some stuff like that as well. So.
And to simplify things, my suggestion would be just to pick a date to end discovery, get all of those things done by a date, say 30 days prior to the hearing date, and not break it down.
I'm fine with that too. I don't want to micromanage. I'm not a micromanager. This isn't my kind of case typically where I'm doing scheduling orders and having to worry about all that. So if you guys, we could say February 1st or February 15th. What's the actual date of the?
Something on January 27th.
That's got moved.
Okay, that's the
to-
only thing that's
What's our,
showing on the calendar.
Ken,
March
do you
20
remember our date?
March 23rd.
March 23rd. Okay.
And so I would suggest that we could say
Mid-February.
complete all of the discovery by February 23rd.
Let me see
30
what,
days prior to the
let me see what day of the week that is. February 23rd is a Monday. Mr. Coleman, any issue with February 23rd being, that's 30 days out for all discovery to be complete?
That kind of puts us on a, I mean, with the type of discovery, the deposition that I'm anticipating, it's a tight deadline, but Judge, I don't have any major heartburn about it.
The only other thing, so June, I don't want to, March 23rd is our day, and then that gives us 2.5 months, which probably is more than enough, Mr. Florence. If,
I would anticipate parties might submit proposed findings of fact and conclude as a law. It might take them a couple of weeks to do that, so that realistically will cut into our time. We have to work on it to analyze all that as well.
okay,
And that's included in my proposed scheduling order is spot for the draft proposed findings of fact.
and I get that that's pretty much, 2 months to get everything done. Do you think that's doable on your end?
Your Honor, I think what will happen, we'll have the hearing. Under the statute, the court reporter has 15 days to prepare the report.
No, I mean if I make that deadline February 23rd.
That's fine, 30 days in advance of the hearing to complete those discovery processes.
Which is about 60 days, 70 days from now,
What my concern
with the
is
holidays.
The holidays.
So really, if you start at January 1 or 2 and get started, you've got about, 45, 50 days to get everything y'all are, is that reasonable?
I think we can do that.
I know that's, and then when I'm getting us past the holidays and being realistic about time expectations, I do want to make sure, if we need potentially, a couple of extra weeks or something for you guys to do your job and a couple of less weeks for us to do ours, I think we could make that work, but we would have to start looking at a new trial date real quick, as in today, and get that figured out.
We can do it, Judge.
Mr.
From our
Coleman,
side.
I know your resources are a little different.
That's right, Judge. Again, it's gonna be tight. I prefer 60-ish days
Yeah.
to complete the entire discovery process.
Mr. Florence, ideas on that?
I was saying that if we needed to seek another extension from the Court of Criminal Appeals, that'd be a third extension. We need some of this.
I'm not inclined to ask for a new extension. The only thing I would be inclined to do is possibly move the trial by 2 weeks. But that lessens everybody's time, to include ours and theirs, to get their findings of fact by 2 weeks.
I think we can do it.
Okay, so if we were to, do you have your calendar available here today with you?
I do, Your Honor.
So right now, we're March 23rd. Let me pull mine real quick and see if we can find an agreeable date towards the beginning of April. And
I'm sorry, a date to change the hearing date? Okay, Your Honor, we will need to check with our experts. They're from out of state. We checked with them on the February.
sorry,
We checked with them on the March date.
Gotcha.
And they were available.
Okay.
We would have to check on a different date if you want to change the date.
perfect. And I would assume you would have to do the same, Mr. Coleman.
Yes.
Let's do this then. Let me throw a tentative date out. If it works for everybody, then I will consider moving it to that date. And you and I can do this by email. We'll include Mr. Florence on that email. I'll send out an email that has kind of formally saying what the date is that I'm about to come up with. And then if it does not work, then the alternative is going to be the dates we're talking about right now, which would mean a trial or hearing date on the 23rd of March, discovery complete by the 23rd of February. So as of now, let's make that where we are. And then if we can, let me pull this up. April. So April. I would say either the 6th, the week of April 6th, which is a Monday, or the week of April 13th at the latest. Those would be the two alternative dates.
Yes, those dates work for us if they work for our experts.
Okay,
We'll have to
Mr.
look at it.
Coleman.
Same.
So why don't y'all do this? I'll get an email out either this afternoon or tomorrow with everybody involved in it with those two dates. If we can get one of those that works for everybody, then I'm willing to push it back. If there's one of those that does not work, then we are where we are.
And you know, we're fine with the date as is.
No, I understand that. I do want to get, Mr. Coleman is in a much different
I
position.
understand.
He's here with me an awful lot in court, and so his time and resources, I think, are a little different than what you guys probably have going on, and so I do want to give him a little bit of leniency if possible to be able to work on this, as well as the other very serious issues that he's working on daily with me. So I'd like to get it moved for him if possible. So if y'all could, I'd like to also have this nailed down before Christmas. And so if you guys can take the next few days and early part of next week to get with those experts, and we'll have an email going, and if we can get everybody on board, you know, by the 23rd, that would be great if possible, so that you know what you're working with as soon as the first hits.
Okay, that'll work.
Yes, sir.
Just one thing, you mentioned something I hadn't contemplated, but if the court reporter takes 15 days to get the reporter's record ready, and then the parties take another 15 days to get their proposed findings, of fact, and conclusions of law in, that might leave us only about 3 weeks to get what we need done. That's probably sufficient and pretty quick, but this is a big case. I know everyone will be familiar with the record by then,
Right.
but depending on what the proposed findings of facts are, it's putting us, we might be in a 3 week, I was doing a rough calculation, I might be wrong, but.
Let's shoot for the 6th. Let's take the 13th out. And so if the 6th works, that would be amazing. I would like to be able to do that for everybody. If for some reason it does not, then the 23rd will be our day, with the 23rd of March being our hearing day, 23rd of February being the deadline for discovery. Okay?
Yes, Judge.
Anything else?
Judge, another important milestone for me at least is the designation of experts. I know that there have been mention of experts, but I prefer to have them a hard date, that they be designated, so I know who to send discovery to.
Any,
And I'm
That's what I
fine,
propose.
I'm sorry, I'm fine, we do need a date.
yeah, for both of you to turn those,
I
what
don't know what it is.
are you suggesting? What's it, either?
Well, let's say we're working from February 23rd, discovery deadline.
Let's do it in number of days. So if your discovery deadline's 30 days pre-hearing, then designation of that way, if we move the date, I'm going to be able to count the days. You know what I'm saying? So designation of experts, how much before the discovery deadline?
In my mind, Judge, I'm thinking 60 days gives me a wide enough window to drop the discovery and have enough time for the responses to come back. And also
60 days
before
hearing.
the completion or the close of the discovery deadline in our scheduling order, if that makes sense.
That's
We got-
next week. That would be next Tuesday.
A little quick.
That's not going to work. So
That's just my preference.
no, I understand. So why don't we make it?
I'm sorry, but if you think about it, you know, those discovery, and it's been a while since I've done similar discovery, but those discovery deadlines have deadlines. If I drop discovery on their expert, it's typically a 30, 45 day, and Mr. Udishin, help correct me if I get it wrong, you've probably done more than of this type of stuff than I have, but 30 days for them to respond.
I mean, and so
45
here's what you've already talked with experts. You're calling them to see if they're available trial. You know who they're potentially going to be, right? So I don't think, unless there's something that you guys don't already have an idea, I would think at this point you've already got an idea who your experts are. So I'm going to make the designation of experts deadline January 5th, Monday, January 5th.
And Your Honor, we know who two of our experts are because they're the two experts that provided affidavits that are already on file. We may have more experts, and because of the holidays, I don't think we're going to be able to determine that by January.
Let's make that still the deadline. I want everyone to get what you can by then. If we're going to keep the deadlines to be able to do discovery, we've got to get that part done, or you're going to run out of time to get your answers on your discovery before we get where we need to get. So I'm going to keep that a pretty hard deadline. If you are working on something specific with regard to one expert says, hey, we need this other person, then I don't want anybody hiding behind the log on this. It is what it is. The experts are who they are. I want to know, everybody needs to know, let's get them out there. And if there's an issue, again, we can come back here, we can get on Zoom, or we can just email and say, look, I think I might have one more. I will know for certain by Tuesday or something like that. And I think everybody can work with that as long as I don't get the feeling that anybody's, trying to hide behind something to get something pushed back. Okay?
That's fine.
All right. Any other deadlines that we need to address?
The only other thing I think is really pressing, Judge, is the draft of the submission for the findings of fact and conclusion of law. Those other things I've listed in my proposed scheduling order, they're kind of like optional, like filing of trial briefs, preparation of trial notebooks, any additional pleas. Those are all things that are I think are minor, but I think the submission of the finding of fact, proposed findings of fact, conclusion of law.
Well, that'll come 10 days.
Have to be after the reporter's record.
So once the reporter's record in, which is 15 days, so once we know for certain what our hearing date is, then I will be able to determine what that date will be. So it'll give you each 10 days after the reporter's record is due. And so I think that would be reasonable, whatever that date is, once I
Yeah,
get this.
and that's fine. I will say this, is that I've never really had a scheduling order in a writ hearing. Really, all we've ever done is list witnesses and then have a hearing.
And
then do our
again,
findings.
I don't want to micromanage. We're not going to go through, like Mr. Coleman said, all the things that are listed in that proposal. I do think it's important, though, that we have some of these key things, the discovery, the designation of experts. Those two things, I think, are very important, that everybody's on the same page. And we're not getting close to the hearing and somebody says, well, I haven't done something and we really didn't have a deadline and I'm still working on it. So I'm good with what we've got. I don't think I need to do anything else as far as scheduling. I've got us right now at a March 23rd hearing date, February 23rd discovery deadline, designation of experts, January 5th. And then the findings will be 10 days after the 15 days that the reporter has for the record. And then obviously if everyone can get that date approved for the 6th, then I will adjust those dates 30 days back, and I'll get all that to you guys in some type of email or order if you need an order.
Okay, I think that's fine.
Okay?
That's all I have, Judge.
Okay.
All right, thank you.
All right, thank you all very
Thank
much.
you.
Have a good trip back. Thanks, nice to meet both of you. Okay, this is 24 DCCR 1369, and sir, you're Terry Rose.
Yes, ma'am.
And Mr. Rose was previously in court, entered a plea of guilty to the offense of murder, and the agreement was for a cap of 40 years in prison. I've received the pre-sentence report as well as 2 letters that Mr. Burbank submitted. Has everyone had an opportunity to review all of that?
Yes, we have, Your Honor. Defense has, Judge.
Are there any additions or corrections to the pre-sentence report?
Not from the state, Your Honor. Not from defense.
All right, then, Mr. Mr. Burbank, do you have any witnesses?
Subject to rebuttal, Judge.
Okay, so you're fine with the state going first?
No, we'd ask, yes.
Okay.
We ask you take judicial notice of what's in the deed.
I will do that as well. All right, Mr. Nichols, you have witnesses to call?
Yes, Your Honor, I did.
You may call your first witness.
Oh, Captain Michael Ponder, Your Honor. I'm going to move the podium to the court.
Well, and I think what we're going to do, if you don't mind, is just Well, actually, if you'll move it and you can just, I was gonna let you guys just stay at table. That's why we've got the,
Okay, if that's what you'd rather.
I think so. I think that'll be better just for the setup that we've got going, if you don't mind. And you can just stand at council table would be great. And also, if you'd like, Mr. Nichols, if you want to pull that podium between you guys, if you feel more comfortable having something like that, you can do that. And then the, how are you, sir?
Oh, she's not swearing.
Would you please swear, raise your right hand? Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You can have a seat. Mr. Burbank, does that block you from the witness? You might want to go back just a little bit more, Mr. Nichols.
You can sit.
No, that's good. You're good. And if you would, just kind of pull that microphone down and speak loudly and clearly so everybody can hear you. Thank you. Mr. Oh, let's wait till everybody gets, finds a spot.
Alan, I'm moving to the front. Sure. Thank you.
Mr. Parker, you can come on the other side where we, yeah. Let's- Go close. Look close. You may proceed.
Thank you, Your Honor. Captain Ponder, would you introduce yourself to the court, please?
Yes, my name is Michael Ponder. I'm the captain of the Jefferson County Sheriff's Office, and I'm the custodian of records for Jefferson County.
What are your day-to-day job duties?
I oversee all records that we maintain, both physical and digital records, everything from physical paper copies of inmate records to phone calls, messages, video recordings.
And at the Jefferson County Jail, are all inmate communications recorded?
Yes, sir. All telephone calls made from inside the dorms are recorded.
And can you explain to the court how that system works?
It is an automated system. Whenever the inmates make a call, they have to verify their inmate ID number with a personal PIN number that they create. And it also has a voice PIN authenticator that it has to match their voice to what the system has on file.
And are all those calls recorded?
Yes, every phone call that's made from the facility has a prompt whenever they first make a phone call stating that all phone calls will be recorded.
And is there an outside company that runs the technology and runs that system?
Yes, it is a company called Smart Communications. They maintain our phone systems.
And as the supervisor for inmate communications at the jail, are you a custodian of records made by that company as it pertains to inmate phone calls?
Yes, sir.
Is the system capable of making accurate recordings?
Yes, sir.
May I approach, Your Honor?
Yes, you may.
Showing you what I've already marked as State's Exhibit number 1 for purposes of this hearing. This is a thumb drive. Have you had an opportunity to review this earlier today?
Yes, sir.
And State's Exhibit 1, it is a recording of an inmate phone call, correct?
Yes, sir.
And can you identify the inmate who made this phone call?
It was Terry Rose.
And it was made on the 17th November 2025, is that correct?
Yes, sir.
Is this a true and accurate copy of the phone call made by Terry Rose?
Yes, sir.
And as a custodian, you can identify this for the court and verify that this is, in fact, Terry Rose making the phone call from the jail.
Yes, sir.
Your Honor, at this time, I'll offer an evidence State's Exhibit number 1. Your Honor, I've been provided a copy and no objection, State's 1.
States 1 is admitted.
And Your Honor, I will publish it later in the hearing.
Okay.
And I have no other questions for Captain Ponder and the best witness.
Thank you. Any questions, Mr. Burbank?
Just several questions. Judge, ma'am. Good afternoon.
Yes, sir.
How you doing? How many phone calls, you're the custodian of the record, how many phone calls has Mr. Rhodes placed at your facility?
I can't tell you the total number. I haven't looked at every one of them.
Well, how much, do you have more than one?
Yes,
More than 100?
I couldn't say it exactly, sir.
Well, because they're only asking about one phone call, correct?
Yes,
And so my question is, through your being the custodian of the record, would you acknowledge that he has made numerous phone calls since he's been at your facility?
I can't tell you how many phone calls he's made, but he has made phone calls up to Seward.
Okay, well, let me ask you this. You were requested by the district attorney to retrieve the phone calls of Mr. Rhodes, correct?
Yes,
Okay, who did that? Did you do it, or did you have someone else do it?
I just verified the phone call came from our system. It is pulled from the DA's office.
Okay, so the DA's office has the number of calls that he made at that facility.
I can't tell you how many calls they called. I was only called witness to one.
So out of all of them, if I represent to you, they had numerous calls, they've only asked you to testify to one.
Yes.
And do you know who he was talking to?
No, sir.
Do you know who he was talking about?
No, sir.
And do you know how long he's been at your facility?
Not the exact time, no, sir.
You don't know when he was booked in?
No.
Thank you. Pass the witness, Your Honor, subject to recall.
Thank you. Anything else, Mr. Nichols?
I have another question for Captain Ponder, Your Honor. I'd ask that he email out to return to duty.
Do you really anticipate any other questions, Mr. Burbank?
I don't foresee any, Judge.
If we need you back, Captain Ponder, just make yourself available, but you're free to go. Thank you.
Yeah.
You may call your next witness.
State calls David Wiley.
Good afternoon, sir. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir. You can have a seat. And Mr. Wiley, if you'll just pull that microphone kind of as close as you can and make sure you speak loud and clearly so that we can all hear you. And if it's a yes or a no question, be sure to say yes or no, and not just a head nod or an uh-huh, so the court reporter can take everything down.
Thank you.
You may proceed.
Thank you, Your Honor. Mr. Wiley, David, would you give your full name to the court reporter, please?
David Wayne Wiley,
And what city do you live in?
Nederland, Texas.
Have you always lived in this area?
Yes.
Were you born here?
Dallas.
And how long have you lived in Jefferson County?
30 years.
Sir?
About 30 years.
Where were you living in the summer of 1999?
Beaumont.
In the city of Beaumont?
Yes.
What kind of work were you doing?
Tow truck driver.
And as a tow truck driver, did you work for Terry Rhodes?
Not at that particular time, but I did in the past.
So as of 1999, you had worked for Terry Rhodes?
Yes.
Were y'all friends?
Yes.
Y'all hang out socially?
Yes.
Do you recall a phone call from Terry Rose the evening of July 9th, 1999?
Yes.
What did he want?
Me to meet him at Walmart on down the road.
Walmart on Dallin Road in the city of Beaumont.
Yes.
Did you meet him?
Yes.
Do you recall about what time this was?
Probably between 5 and 6, after 5 o'clock work.
You would have gotten off work at 5,
Yes.
and this happened shortly after that. Is that right?
Yes.
So when you went to Walmart to meet him, what did you see?
He was in Kim's car.
Now, when you say Kim, who is that?
Kim Langford.
Kimberly Langwell?
Yes.
Did you know her?
Yes.
Did you know her to be an ex-girlfriend of Terry?
Yes.
Did you know for them to be close and have lived together for some time?
Yes.
Were you surprised when you saw him with her car?
Somewhat.
What did he say or do when you got there?
He said he wasn't happy with the location and for me to follow him down the road
And where did you follow him to?
to the corner of Dowling and Phelan.
Is that known as the Westmont Center?
I believe it is. Used to be a Deckard's store there and Market Basket and other businesses.
And what did y'all do there?
He parked the car and got in my vehicle and I drove him home.
You took him back to his house. Where was his house at the time?
On Lindbergh.
About a mile away?
give or take.
Did you see him, what was said, or what did y'all talk about when you were dropping him off at his house?
Very little other than just I would see him to shoot pool later that night.
Did you go shoot pool with him that evening?
I did.
Where was that?
Corner pocket,
Now, where's the corner pocket in relation to where y'all left her car?
probably 60, 80 yards from there.
Same shopping center, isn't it?
Correct.
Same parking lot.
Yes.
Did he tell you at that point why he needed to move her car?
He did not.
Did y'all hang out, drink beer, shoot pool that night?
We did.
How was he acting?
Normal.
Did you see him the next morning?
I did.
What'd y'all do the next morning?
Ate breakfast at Iron Skillet.
And what was that conversation like at breakfast?
Just kind of normal conversation about plans for the day.
Did Kimberly Langwell come up in the conversation?
I don't remember if it did or not.
Well, when did you have a conversation with Terry Rose about Kimberly Langwell?
Sometime either Friday night or the next day sometime that he told me
What did he tell you?
that he had shot her.
Did he give you any detail as to how that happened or where he shot her?
The only thing he told me was the back of the head.
That he shot Kim in the back of the head.
Correct.
Did you ask why or what happened or anything like that?
I think I was too dumbfounded to ask anything else.
Did he tell you anything else about shooting Kim?
No.
Did he indicate it may have been an accident or anything like that?
No.
Did he tell you where Kim was?
No.
At some point, did he tell you what he had done with Kim's body?
Yes.
When was that?
I believe it was sometime that weekend
And what did he tell you?
that he had dug a hole in the slab and put her under the slab
The slab where?
in his house.
House on Lindbergh.
Yes, sir.
That's where he lived, correct?
Correct.
Did he tell you which bedroom?
So I believe he indicated it was the front bedroom closest to the street.
And what was your reaction to being told that your friend had shot and killed a woman and buried her in his home?
Shocked, and astonished, didn't know what to think.
Were you scared?
Absolutely.
Were you scared for your own life?
I was.
Now, the police asked you about this in 1999, didn't they?
Yes, they did.
And did you tell them the truth about what had happened and what Terry had said?
No, I did not.
Why not?
I was afraid that I was involved in something that was gonna have me in deep trouble.
And so you kept your mouth shut, didn't you?
I did.
You kept Terry's secret
I did.
for a quarter of a century. Is that right? In 2024, were you again interviewed by Beaumont Police and called as a witness to testify in front of the grand jury regarding the disappearance of Kimberly Langwell?
Yes, I was.
And did you at first maintain the same story that you had originally told the police, that you didn't know what happened?
Yes.
After you did that, what happened?
After the days started going by, the thoughts just got too deep, too hard on me. I just couldn't put up with it anymore.
Did you contact an attorney and through them reach out to the district attorney's office?
Yes.
Or Beaumont Police?
Yes.
And tell them what?
Told him what happened, what he told me.
You wanted to tell the truth.
Yes. I couldn't live with it any longer.
And then did you give a statement to the effect of what you told us earlier?
Yes, I did.
That Terry Rose admitted to you he shot and killed Kimberly Langwell, shot her in the back of the head, and buried her under the slab of his house.
Yes.
Was that the truth?
Yes.
25 years after it happened, what made you come forward?
I didn't want to live it any longer. Tired of it being on my conscience.
Had you told anybody during those 25 years what Terry had told you?
No.
Is there any, do you have regret for not telling the truth earlier?
Absolutely.
Is there something you want to say to Tiffany McInnes and her family?
I wish I came forward right when it happened.
Was it hard for you living 25 years knowing this secret?
Yes, very, very hard.
And you and I spoke about this. Is it weighing on you still, weighing on these years?
Yes.
At any point, did Terry bring this back up in the times you've seen him in the last 25 years?
No.
Have you seen him off and on since this?
Yes, I have.
And he never brought it up?
No.
I'll pass the witness. Thank you, Mr. Wells.
Thank you, Mr. Nichols. Mr. Burbank?
Good afternoon, Ms. Wiley. Back in '99, July of '99, how many times did the police come and talk to you when it first happened?
Just once.
Just once? And did you take part in trying to find Kimberly?
No, I did not.
You realized that they were trying, or they were a big effort in trying to find out where she was? You realize that, right?
Yes.
Search parties, going out, putting flyers around, asking anybody and everybody, billboards, things like that.
Yes.
Did you take part in any of that?
No, I did not.
You said at one time you were an employee of Terry, right?
Yes.
After this incident, were you employed by him? Did you work for him?
One at a time.
Okay, and how long did you work for him?
A year, maybe two.
Okay, and was he married at the time?
I don't know.
Did he have people living at the house?
I don't think he did. It was strictly a business. I didn't go to his house to see if anybody was living there.
And during that time, do you know roughly how long you lived with him between '99 and 2024?
Live with who?
I mean, I worked for him, excuse me.
Oh, probably 2 years.
Okay. During that time, you would see him on a daily basis?
Generally.
Never said one thing to him saying, hey, man, you gotta say something to somebody?
No.
Never did. Never went to the police?
No.
Back in how many times did you talk to the police between the original time in 1999 and 2024 when they came to your house just before Thanksgiving?
None.
You had a chance to tell them when they came to your door, right?
Yes.
I think it was two detectives, Detective Wilson and Detective Tamayo.
Yes.
You didn't tell them that?
No.
After that, you were called back into the grand jury, correct?
Correct.
And you could have told them then.
Correct.
Did you have conversations? When did you start that? When did you actually stop talking to Terry after this incident? How long from today forward? I know he's been in jail since he's been arrested, but
The last time I spoke to Terry was in February at the swap meet in Conroe.
and what year was that? Is that 24 or 23?
24, I think.
24. So you basically have kept in contact with him up until the time he was placed into custody. You talked to the police, what, in April of 24? That sound about right? Or was it August? Well, April? May?
I'm not sure on the dates.
And you would agree not once until just recently, when I say that, within the year, last year, you said anything to anyone?
Correct.
Pass the witness, Judge. I have no other questions, Mr. Wiley, Your Honor.
All right, any objection to Mr. Wiley being excused? Thank you, sir, you're excused. Do you want to move that microphone to the podium since we've changed? Would the microphone over here be better on the podium?
Thank you, Dave.
Thank you, Judge.
Yes, sir. You may call your next witness.
State calls Heather Wilson, Your Honor.
Good afternoon, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you. You can have a seat. You may proceed.
Thank you, Your Honor. Detective Wilson, would you give us your name and introduce yourself to the court, please?
Heather Wilson, I work for the Beaumont Police Department as a detective.
And as a detective, what's your assignment? What do you do?
We're assigned criminal cases. We file those cases with the district attorney's office, make arrests.
And are you assigned to a particular division with Beaumont Police?
I am, yes.
What is that currently?
It's called the Persons Unit.
And how long have you been a detective with persons?
Almost 7 years, just shy of 7 years.
And how long have you been in law enforcement?
17 years.
Where did you start out?
As a patrol officer,
Here in Beaumont?
yes.
Did you attend a police academy?
I did, yes.
And what kind of certifications and trainings do you have that allow you to work as a police officer?
I have a master's peace officer's license and thousands of hours of training and anything from crime scene to interviews, firearms, stuff like that.
Okay. And then your work as a detective with persons, were you part of a team that essentially reopened the investigation into what was considered a missing persons case of Kimberly Langwell?
Yes, I was.
And when did y'all begin to reopen that investigation?
That was in the spring of 2023.
And when was Kimberly Langwell first reported as missing?
July 9th, 1999, or actually on the 10th reported.
And you weren't working for Beaumont Police back then, were you?
I was not, no sir.
But y'all essentially reopened that file and began re-interviewing witnesses and examining the evidence again, didn't you?
That's correct.
You, along with several other detectives in the persons unit.
Correct.
And in the course of that investigation, y'all went back and interviewed some of the same witnesses who had been interviewed before.
We did, yes sir.
Y'all interviewed David Wiley, is that correct?
We did.
And initially, did David Wiley maintain the same story he had told police in 1999, that he knew nothing about what happened to Kimberly Langwell?
That's correct. That was the same story he told us.
And after giving a sworn statement to that effect, did he want to revisit his statement with y'all?
Eventually, we asked him if he would take a polygraph to kind of gauge his truthfulness on that statement.
And so did David Wiley change his story from what he had originally told police?
He did, yes.
What information did he give you?
He provided us information that he had a conversation with Terry Rose, and Terry told him that he killed Kimberly on July 9th, 1999 inside his residence, and that he had planned to bury her under the slab of the house.
And well, was that quite a shock to hear?
It was, yes.
That confirmed what was initially suspected but never proven in the investigation
Correct. Yes,
from 1999.
yes.
So based on that information, did you and the other detectives with Beaumont Police obtain a search warrant for Terry Rose's house on Lindbergh in the city of Beaumont?
We did, yes, sir.
And what was the time frame for that search?
It started on June the 10th of 2024 and went to the 14th.
And it was a search of his house and the several acres of property surrounding?
Correct, yes.
Can you just summarize for the court how the search went and what you found?
We ultimately ended up finding human remains. We had started with calling in EquiSearch for assistance, and they brought in ground penetrating radar.
Texas EquiSearch is a volunteer organization that assists with missing persons,
Yes.
with locating bodies, with
Yes,
really helping find people, isn't that what they do?
yes, and they were able to bring in the equipment that we needed to kind of help search the floor area that Mr. Wiley had indicated that she could be under. So
And with that ground scanning radar, what did they observe?
they observed an area in the front bedroom of the house that was, it appeared that it was missing a piece of rebar. So that's kind of where we focused our search on.
A normal concrete slab of a home is going to have rebar embedded in the concrete, isn't it?
Correct, that was an abnormal finding for them.
And so they were able to locate an area that had no rebar.
Correct,
Did y'all start digging?
we did, yes, sir.
How long did that go on for before y'all found it?
Probably about an hour. Within the first hour, we found a pair of broken sunglasses, a keychain, and a lighter were the first pieces of evidence that we found that were definitely out of place.
And so at that point, did y'all believe y'all had found the grave of Kimberly Langwell?
We did. We knew we were in the right area. Yes, sir.
How is that site excavated and how is everything cataloged and preserved?
Yeah, so we were there with the FBI team who had like a crime scene unit with us, and we basically just started sifting through the dirt and the sand very slowly. We put that dirt and sand into buckets, which were brought out to a sifter. And we had a crime scene unit that was sifting very carefully through all that dirt. And
How long before y'all found what you believed to be human remains?
Maybe within an hour or two, pretty quick.
And eventually was, what appeared to be a full skeleton located?
Right, yeah, they first located 3 small bones that we were able to verify were human toe bones.
And so from there, they continued the excavation.
And then it took a couple more hours to kind of get to the main part of her remains, and she was wrapped in a blanket, and so luckily it appeared that everything was in there, but that's when we found the further extent of the rest of the bones. Yes, sir.
And those human remains, were they sent, well, first, an autopsy was performed locally, correct?
That's correct, yes.
And do you recall the findings of the autopsy? Did they
Yes.
observe any trauma or damage to the body?
Yes, she had a gunshot wound to the back of the head.
Can you indicate for me approximately where?
It was kind of towards the base of the skull, towards like where the spine would be.
And after the autopsy was performed, were her remains sent off for further examination by a forensic anthropologist?
They were sent to the University of North Texas in the Dallas area, and they have a forensic anthropology unit that further examined her.
And they compared her remains to known dental records, didn't they?
They did, yes.
And along with another surgical appliance in her foot, were they able to identify that as Kimberly Langwell's remains?
Yes, she had a screw in her foot from a previous surgery and a retainer in her mouth. So with dental and bone findings as well, they had.
And then after that analysis was done, were DNA samples sent off to a lab to compare with samples taken from her daughter, Tiffany McGinnis?
That's correct. We took a swab from Tiffany, and then we had DNA extraction from the remains that we found, and it was essentially a maternity test that confirmed that the remains were the mother of Tiffany McGinnis.
So 25 years after she went missing, Kimberly Langwell's body was discovered under Terry Rose's house. Is that correct?
That's correct. Yes, sir.
With a gunshot wound to the back of her skull, consistent with what David Wiley said Terry Rose told him he did.
Yes.
Shot her in the back of the head.
That's correct. Yes.
At any point in your investigation, has Terry Rose, or at least leading up to the investigation, did Terry Rose ever indicate he knew what happened to Kimberly Langwell?
No, he did not. We had interviewed him several times, and he indicated that he did not know where she was or what happened to her.
At the time this happened, he was considered a suspect, wasn't he?
He was.
He was the last person that admitted to having seen her and spoken to her.
That's correct.
But no physical evidence was discovered at the time of the crime.
That's correct.
Was there ever, once the body was found, was Terry Rose arrested?
He was, yes.
Was he given an opportunity to speak with Beaumont detectives?
He was. We tried to interview him immediately after his arrest.
And did he want to talk to y'all and give an explanation of what happened?
He did not. He said, nobody will believe me, and he didn't want to tell us his version of events at that time.
At that point, he was placed under arrest and was formally charged with the murder of Kimberly Langwell.
That's correct.
In all this investigation, has there been any evidence to suggest this could have been an accident or unintentional act?
No, sir.
Bullet wound in the back of the head is pretty telling, isn't it?
It is, yes.
Hiding a body under your home for 25 years and lying about it, what does that indicate to you?
Yeah. I mean, it was a massive cover-up, for sure.
And over the years, no one else had come forward until y'all spoke with David Wiley and he finally came clean.
That's correct.
And based on his statements, y'all were able to locate Kimberly Langwell and bring this case to a close. Is that
We
correct?
were, yes, sir.
Thank you, Detective Wilson. I'll pass it.
Mr. Burbank?
Just a couple of questions.
Sure.
Good afternoon.
Good afternoon.
How you doing?
I'm well. How are you, sir?
You had a chance back in to go back over what happened back in 1999, the original case.
I did. Yes, sir.
And in your file, did you see or did you read anything in reference to a search of Mr. Rose's house?
Yes, sir.
And did your department go and search the inside of the residence?
They did, yes.
And there was no indication whatsoever that the slab was,
They didn't document it too well as far as what they observed, but there was no notings of that anywhere, no, sir.
in reference to if this happened on July 7th, do you know how long after they possibly went in there to search the residence?
It was July 11th,
So it was within a couple, 3-4 days.
2 days.
And at that time, did Mr. Rose allow them to come in? I mean, it wasn't a search warrant. Did you read that he gave consent?
He did give consent, but again, it wasn't documented too well on if it was an indoor search or an outdoor search or a combination of both, but my assumption is that he did, that they did go inside.
The other thing that I noticed during the investigation is that you called in a number of witnesses again in front of the grand jury in 2024.
We did.
April, was it?
It was, yes, sir.
And were you present when Mr. Rose gave testimony in the grand jury?
I was, yes.
And were you present when the grand jury attorney asked whether or not he would consent for the law enforcement to go back into his house and search?
I was, yes.
It was kind of deep or intense. I mean, it went on for a little bit. And
Yes.
he never said, no, you couldn't do it, or no, you have to get a warrant.
Correct, yeah, he consented.
And when he went up to, there were several interviews after the 99 incident, that's what you witnessed, correct, with law enforcement and Mr. Rose?
There was.
And he never lawyered up, did he?
He did not.
And even when the grand jury, he was asked to come as a witness, he didn't get an attorney then either, correct?
He did not, no.
And he answered everyone's questions that they asked.
He did, correct.
But of course, he didn't admit that he had any knowledge of what happened to Kimberly Ryan.
He did not, yes, sir.
And at the time that you asked him, once you discovered her body, and that you asked him if he wanted to talk, was he already in custody?
He was, yes.
And do you know if he had an attorney at that time?
He did not, no, sir.
But he elected saying, no one would believe me anyway, and I don't want to talk to you.
Yeah, he did.
When you did your investigation, and I think that the state questioned it, in your opinion, based on all the evidence that I received, and what I guess you had too, nothing in reference to any type of maybe lesser included manslaughter or negligence that would possibly be an option in this case?
No, sir.
You think it was intentional and knowingly?
I do,
And
yes,
it was
sir.
based on all the evidence and investigations?
Yes, sir.
Totally.
Yes, sir.
Mr. Rose's criminal history? 0,
Yes, sir. He did not have one.
even after this incident?
Correct.
No run-ins with the law,
Correct. This was his first arrest
ever?
ever.
Thank you, Detective.
All right, thank you.
Yes, please.
Thank you, Mr. Burbank. Mr.
I have
Nichols?
another question for Detective Wilson. Your
Any
Honor.
objection to Detective Wilson being excused?
No.
Thank you, Detective, you're excused. You may call your next witness.
State calls Tiffany McGinnis, Your Honor.
Good afternoon.
Good afternoon.
Do you swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, you can have a seat. You'll just kind of pull that close, just so everybody can hear you when you're answering. Thank you.
This is good.
Yeah, it's good. Go ahead.
Thank you, Your Honor. Tiffany, would you give your full name for the court, please?
Tiffany Marie McGinnis.
And you're Kimberly Langwell's daughter, aren't you?
Yes, sir, I am.
So Tiffany, I'm sorry you have to be here.
You too.
But I want to go back and inform the court as much as we can about your mother and what life was like in 1999, okay?
Okay.
So in the summer of 1999, July of 1999, when your mother was murdered, how old were you?
I was 15 years old.
And did you live with your mother at that time?
I did.
Where did y'all live?
We lived on Josie Street in Beaumont.
And how long had y'all lived at that address?
Approximately, I don't know, 15 months, a little over a year.
And before that time, where had y'all been living?
We lived with Terry Rose,
At his house on Lindbergh.
1655 Lindbergh.
How long did you and your mother stay at that address?
5 years.
Now, what was your mother's relationship with Terry Rose?
He was her boyfriend
For how long?
for those 5 years.
During the time that y'all lived there, is that right?
Yes, sir. I believe I was in 3rd grade until 8th grade, yes, sir.
So for the year and change before your mother passed away, had she and Terry been dating?
Yes.
Well, at what point did they stop seeing each other?
To my understanding, whenever we moved out of his home.
And so when y'all moved out, was that the end of their relationship as far as you knew?
As far as their relationship as boyfriend, girlfriend, in my understanding as a 15-year-old, that was the end of them. He would still come around, but that was my understanding of what was going on.
And then the months before your mother was murdered, had she started seeing somebody new?
She was.
Who was that?
His name was Ken Weatherford.
And did they have a serious relationship?
I believe so, yes.
Did y'all spend a lot of time together?
We did.
July 9th, 1999. Do you remember the last conversation you had with your mother?
Of course.
And can you tell the court what that was?
She called me and she had just gotten off work. She told me that we had made plans that day that we were gonna go out to eat with her boyfriend Ken for dinner. She wanted to make sure that I had invited a fun friend that day because she was in a good mood and she was trying to make Ken feel better about something that he was going through. She was happy, and she told me that she was gonna stop by Terry's, that she had to help him with something. I don't know, it was something about hanging a board or something. I didn't really pay attention to it.
Did that seem weird to you at the time that she would be going by Terry's house, or did that happen fairly often?
I don't remember her stopping by Terry's house very often. I know that they talked and that he was around. She knew that I didn't like Terry and that I had gotten to the point with her that I had stopped giving her grief about it. You know, she had a new boyfriend and I just concentrated on the fact that we had plans that evening and moved on with things.
And so, roughly what time was it that she called you?
It was after work and she had gotten, you know, she usually left work around 5, so maybe around 5:30.
When did you think something may be wrong?
Whenever she didn't show up, it was odd. She didn't just not show up for things. Whenever I started paging her that evening and Terry told me he didn't know where she was.
So after you didn't hear from her, did you call Terry?
I did.
Did you ask him if he knew where your mother was?
I did.
What did he tell you?
He told me that she had left.
That she had left his house?
Yeah.
And did he have any idea where she was going at that point?
No.
What'd you do next?
I started texting my mother. We had a code, you know, like an emergency code because of something that had previously happened before. So I texted her 911. That let her know that, you know, like I was worried, please call me. And I never got a response.
So were you home alone while this was going on?
Ken stayed there for a while before he decided that he was gonna go home. I can't remember how long, it's been a very long time now. And my friend that was supposed to go out to eat with us that night eventually showed up and stayed with me that night.
You know that her car was located in the Westmont Shopping Center by what used to be Eckerd's Drugstore. When was the car located?
I knew about it the next day. Apparently, her boyfriend Ken had seen it on his way home the night before.
Did you go to the shopping center?
Me and my aunt did, yes. we
Who's
did.
your aunt?
Susan Butts.
And y'all could tell it was her car, couldn't you?
Yes, absolutely.
So what, did y'all call anyone for help?
We did.
Who?
We called Terry Rose for help.
And what did Terry do?
He came and unlocked the car.
Did he linger? Did he stay around?
That was it. He stopped, he unlocked the car, and immediately got in his wrecker and left.
Did he say anything?
I don't remember.
Do you remember, was he acting unusual? Was he angry? Acting weird?
No, I was used to Terry asking me questions where my mom was, what she was doing, so to me, it was strange that he asked nothing. Whenever he left, I remember looking at my Aunt Susan and saying, that was strange.
He gave you a bad feeling, didn't
Yeah, it did.
he? What would have been normal for you, 15-year-old you, is Terry would have been asking, where's your mom, what's she doing? Is that right?
100%.
So, at what point did y'all get the police involved?
We actually had gotten them involved before we went and saw the car. I had called my aunt the next morning and reported, she told me to call the police, and we reported the fact that my mother didn't come home. And it seemed like because she was an adult, there was really nothing that they were gonna do at that time.
Once the car was located, did they ramp up the investigation a bit?
I don't remember. I remember that they didn't come out there with us to see the car. I don't know at what point that they got more involved, but sometime soon after.
Can you explain to the court what those first few days were like, not knowing where your mom was or what had happened to her?
It was terrifying. It was shocking because I had just talked to her. She was just on the phone with me, and she was excited for our plans. She was joking with me. And so I was lost. I didn't know what to think.
At this point, you're 15 years old?
Yeah. 15, my mom is the person that I go to for everything. No siblings, it's just been her and I. So, lost, very lost.
As those days turned into weeks, and then months, and then years, can you tell us what that was like?
You know, the first year, I think I threw myself into anything I could to try to get through life, to not think about the fact that she wasn't there. But then you go home and you don't go home to your mom anymore.
Where were you staying?
I was staying with my Aunt Susan. And so life is different. It looks very different. We spent a lot of time going to the police station, a lot of time doing vigils and posting posters and anything that my aunt could do to try to figure out where she was, what happened.
You said y'all put up posters and was there physical searching go on, people looking for her?
Yes.
Were there billboards?
There was a billboard.
Do you know who put that billboard up?
Terry Rose did.
Terry Rose put up a billboard to help find your mom.
Yeah. To find my mom when he knew where she was at.
So, about how old are you now?
I'm 42.
And a couple of years ago, when the investigation gets reopened, and there's progress being made, and then David Wiley finally comes forward and says, here's what happened. I'm sure you were every step of the way followed what the police were doing.
Absolutely.
When did you find out they had found your mother's body? Or her remains?
June 13th, 2024.
What were you doing?
I was actually driving to Belmont. I knew the search was going on. I had been in constant contact with Heather Wilson. And I actually was driving very close to Lindbergh. I'd just gotten off work early. And she called me and said, hey, we found human remains. And I just screamed and pulled over my car.
For 25 years, she was missing. Now she's been found. After they recovered her remains and did the testing, the DNA testing, and said, yes, we know this is Kimberly Langwell, were you able to have a funeral? When was that?
Say that again, I'm sorry.
Were you finally able to lay her to rest?
Yes, sir, we were.
When was that?
That was October of last year.
Of 24.
Yes, sir.
Tiffany, you know, we have essentially an agreement where Terry Rose pled guilty to the murder of your mother. And as part of that, Judge West can sentence him anything up to 40 years.
Yes, sir.
What are you asking the court to do today?
I would make him sentenced to at least 40 years. I think he deserves that.
And you and I've spoken, there's not a number that really makes this right, is it?
No, there never will be.
Thank you. I'll pass it.
Thank you.
Thank you. Any questions, Mr. Burbank?
No questions.
All right, thank you, ma'am. You can step down.
Thank you.
Let me call your next witness.
Your Honor, I'd like to publish State's Exhibit 1 at this time.
Sure.
State of Texas rests, Your Honor.
Thank you, Mr. Burbank.
Your Honor,
I mean, thank you, Mr. Nichols. Mr. Burbank?
We rest. I didn't know what section he was going to play, and I'm fine.
Is there more that I need to hear?
No.
All right, so no other witnesses? No witnesses, Mr. Burbank?
No, Your Honor.
All right, Mr. Burbank, you may make argument.
Hey, police court, counselors. As you well know, we've been doing this a long time, Your Honor. I guess I longer than you, and there are no winners in this case. Problem with this case is that if it was, I guess, called upon or detected or police were notified and she was found, it might have turned out differently, or there were other facts and circumstances that might have arose. There's a couple of things I'd like you, but it didn't. And no matter how you look at it, Your Honor, if there were facts and circumstances at the time of this incident, they are bygone, and they're not here anymore because of the 25 years of where that person was, Kimberly was placed. And that's the sad part about this. When you look at this and you look at people in reference to representing him as a defense attorney, I look at things. For instance, in State's Exhibit number 1, I wanted to make sure that the court realized that he, no matter what, he was not talking about Kimberly Langwell. He was talking about the daughter. And as the court is well aware, there is also a civil trial going on in reference with her family.
So dumping pee on the grave was whose grave? Who's he talking about?
He's talking about the daughter.
What
and
daughter?
not her, not Kimberly.
The daughter's alive.
I know, they were talking about it.
Okay.
Because, and it had to deal with the civil case that's currently pending.
Okay.
It was not,
Okay.
it was not for Kimberly. And it's reflected in that, Judge, in reference to
things that supposedly she should have done about telling about mom. You have a gentleman here, though, unlike a lot of other cases that you see before this court, that has no record. He has gone 68 years, and there is no record. There is nothing there that says he's lived a troubled life, in the sense of that he's had a secret. He has, and I asked the court to take judicial notice of the two letters that were written, one from his aunt and one from his daughter. One of the things that I believe that was brought out, he is relieved at what happened. It has been eaten on him, just as Mr. Riley. He's sorry for what he did. He's tried to explain within the PSI and in reference to the version that he has given. I can't tell you what, if any, consideration that you may be able to give him based on the ultimate facts and what's happened. But you have an individual that has not been in trouble, that has been employed, except he kept a secret. And he kept a secret to the detriment of a family that was grieving at the time, and wanted to know where their loved one was, especially a 15-year-old girl, and that he can't erase. I would ask for any consideration, if any, of course, of his age, because of the nature of the offense of being 3G under the Texas Code of the Penal Code and Texas Code of Criminal Procedure. So any consideration that you might give, but there's a cap of 40. Thank you.
Thank you, Mr. Burbank. Mr. Nichols, can you play that again for me, please? I just want to make sure I'm...
I can, Your Honor. I'll represent to the court. He's not talking about Kimberly Langwell.
Okay.
And I'll make it part of my argument.
Okay, go ahead then.
The phone call you heard, Judge, was him talking about how it greatly inconvenienced his life to have to deal with a parole board should he ever make it that far. And that, no doubt, Tiffany McGinnis would tell the parole board not to let him out early. That's what he's complaining about. And his son, who's the other end of that phone call, mentions, well, maybe something will happen to him and she'll die. She's in her 40s. And his response to that is, I would gladly pee on her grave, Your Honor. And the reason I play that, along with a lot of the other evidence we heard today, shows this man has no remorse, no feeling whatsoever for what he did to Tiffany's mother and what he's done to this family.
If you want to testify, you can get up here and testify. Otherwise, you have refrained from doing that, and so stop talking.
And on that call, he blames a then 15-year-old girl for not telling him that her mother had moved on. And that's sick and twisted, Your Honor. No more sick and twisted than living in a home with your murdered ex-girlfriend under your floor. A home that he later shared with his common law wife. A home that no doubt people came and went in for the last 25 years. With Kimberly Langwell buried in a shallow grave under her. Every step of the way has been a slap in the face to Kimberly's family. Every step of this is just inhumane. To go there the next day and open up the car for them, knowing what you did. To tell somebody and expect them to keep the secret for 25 years. To put up a billboard and pretend you're trying to help find her it is vile, it is inhuman, and it is not worthy of any consideration from the court, Your Honor. The cap is 40 years because of his age. And I'm asking the court to enforce that full 40 so Terry Rose spends what's left of his life behind bars, Your Honor, because that's what he deserves. Thank you.
Thank you, Mr. Nichols.
You want us to rise, Your Honor?
I don't care. it's not often that I'm at a loss for words, and honestly, it's because I have too many words. And anything I say is not going to help Tiffany and her family other than getting this over with, which is why I pushed this to get done today and not wait until the end of the year or the first part of next year. But there's just certain things that I can't even look past to not point out. The fact on that phone call that you said you're not a psychopath is just beyond me. Who isn't a psychopath that kills someone that they once cared about and buries them in their house and lives on top of them for 25 years? I would think that's the definition in Webster's dictionary of a psychopath. It's not a bad day. It's a bad 25 years for her. I mean, it's the nonchalantness about how you spoke about this told me way more than I really needed already with what I had. But that is just the fact that you think for some reason that me running for re-election or Mr. Nichols running for election has anything to do with what we're doing today. It does not. You can ask anybody here, any of this law enforcement. I've never made a decision because of politics, and I never will. And Tiffany's right. 40 years isn't enough. There is a part of me that wishes I had not accepted this plea agreement and that we had gone to trial last week, because I do think a jury would have given you life for 99 years. I actually do. If they had heard that, you would have gotten that. And the fact that you thought you wouldn't is the most narcissistic thing I think I've ever heard in my entire life. So, I mean, there's just so much more. The billboard, I mean, it's insane. It's psychotic. That's what it is. I'm going to find that you previously entered your plea of guilty freely and voluntarily. I hope that today gives Tiffany at least some final closure on all of this and her family. I'm going to sentence you to a term of 40 years in the institutional division of the Texas Department of Corrections. If I had 50, I'd give you 50. If I had 60, I'd give you 60. Whatever it was that the cap was going to be, after hearing all this, it would have been whatever it was. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was an agreement, so you have no right to appeal, which also is one of the only reasons that I accepted this plea agreement, because that does make this final. So there's no appeal, there's no chance of anything happening, it's over. I highly doubt that this matters, but I am required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about that, you can talk to Mr. Burbank about how long it is or the eligibility. Again, I don't anticipate that being an issue. I want to thank every single law enforcement officer that's here, really on behalf, I think, of Tiffany and the family as well, Mr. Nichols and Mr. Canal, for the work that's been put in for 25 years to finally get this taken care of. At this time, you can go with the bailiff. Oh, wait. Is there a...
Yes, Your Honor.
Sorry, we're going to do a victim impact statement. We'll go off the record.
After hearing sworn testimony, reviewing forensic evidence, and listening to witnesses who carried this secret for decades, the courtroom is left with a sobering reality. Time doesn't erase accountability. This case shows how silence can delay justice but never destroy it. From inmate phone recordings to forensic confirmation and emotional victim testimony, every piece mattered. If this case shocked you as much as it did us, hit that like button, share your thoughts in the comments, and subscribe for more real, unfiltered courtroom breakdowns.